Just to start out with, since it's Monday, the band pick of the week for Monday is Maddie Pryor. Has anybody heard of Maddie Pryor? Yeah. Well, actually, she's about, I think she's 73 years old. She's been around for a long time. So you probably should have heard of her. She's English. She's the lead singer in a band called Steel Eye Span. Which you may not have heard, but you probably should have. Anybody heard of Fairport Convention? Man, okay. This is British folk rock, all right? So this is a genre which you really should learn a little bit about, all right? So Fairport Convention is another band in that that you might want to listen to. But anyway, Maddie Pryor, take a look at, take a listen to her. She's, again, you can get on Spotify or whatever and take a look. All right, and then I'm going to take roll here. Danielle. Okay. Daniel. Joy. Tyler. Tess. Okay. Sabrina. Andrew. Andrew's grown a beard since his picture was taken. See, like, are these pictures off from when you were a freshman? Is that where they? Yeah. Okay, that's really interesting. Okay, and of course, he was in my 105 class as a freshman. So, Michael Hagestad, here. Joseph. Kaisa, Josiah Johnson, Nathaniel Jones, Lucy, Robert Lowry, okay. Conrad, Isabella, okay. Melody McDonald, Emma, Mike Perry, Alexander Reed. Oh, over there, okay. Okay, Ethan, Jack Shelley, Parker. Parker's pictures in the, right? You were an intern in the, yeah, okay, so you can hand that back up to Parker. He's he interned at the Mackinac Center, and his pictures in there. All right, Ryan Thompson, Grace, Stephanie, and Aiden. Okay. All right. So last time we were talking about civil law and common law, and one of the things I did was I put in the folder in the Wolfram 472 folder in the section that is 3. I put in an article on the difference between common law and civil law. So you might want to just take a look at that, and it'll give you a little more background on that. As we said, in common law, that was when we were talking about Warren Zevon and Lawyers, Guns, and Money, that it tends to be adversarial process. And in the civil law, judges do more as inquisitors. They ask questions, right? So in the common law, your attorneys are talking back and forth, and the judge is sort of just listening and acting as a referee in some sense. Whereas in civil law, the judges are more like a as an inquisitor. And in juries are more, if you look at juries tend to be more in common law, places that have more common law. And in the United States, either party can request a jury. Or you can waive that right. You can say, hey, I want to have a jury trial, or you can waive the right to a trial. In England today, judges tend to settle civil cases, and criminal cases are mostly jury trials. Now, interestingly enough, we're looking at civil law. There's basically two, if we might say, definitions in some sense. That is, we've been talking about criminal law, or excuse me, we've been talking about civil law and common law, right? And civil law is mainly statutory law, and common law is mostly precedent, right? So wherever it's sort of a case law situation. But we'll also make a distinction, as you see at the end, we'll make a distinction between civil law and criminal law. And that's going to be whether it's a crime or whether, like, you violated a contract or something like that, right? So there's also going to be this distinction between civil law and criminal law. And again, I put an article which is a discussion between the difference between criminal law and civil law in the folder Roman numeral 8 when it's about criminal law. So anyway, you'll notice that sometimes I'll be talking about civil law as the statutory way of doing it, Napoleonic idea, and we said that France they decided that civil law was better than the kings being able to declare stuff. Okay, and so anyway, in England today, that the criminal law is criminal cases are mostly jury trials, whereas judges settle civil law, which would be, let's say, you violated a contract, okay, or you trespassed onto my property or something like that. All right, just as something to note is that in the U.S., about 90% of cases never go to trial. That is, they settle. Mostly, if you're suing somebody, what happens is you tend to make a settlement rather than going through the whole process. Or you might, I don't know if you read the Hillsdale Daily News, but if you do, they'll be talking about here's who got arrested or whatever, and then what happens, and you'll find that most of the time they plead to a lesser charge. Okay, this is not unusual. And again, if you sort of think through why that might happen, if you look at the expected value of things, right? You got to look through and say, okay, what's it going to cost to go through this trial? What's the chances that I'm going to win? What's the chances it's going to go to appeal, et cetera? And so you can see that it's probably not unusual that a lot of these cases would be settled out of court. Now, another thing that we can talk about is a hierarchy of law. All right. And again, in terms of a hierarchy of law, what do you want to do? That is, there's different levels of law. And the idea that, if we sort of think back to Aquinas or whatever, you might have divine law and then natural law and then human law. And human law couldn't violate the natural law, and natural law couldn't violate divine law. And then John Locke talked about levels of law. But for those of you, a bunch of you had Econ 105, right? Well, we talked about Hayek. right, in the Constitution of Liberty. And what does he say? Well, he says, you know what? The U.S. is the first place to write it down. In the Constitution of Liberty, he says, the United States is the first place that you wrote down, here's what this hierarchy of law is. So I can go look it up in the Constitution. Again, that's why the book's called The Constitution of Liberty. But the idea that you have a hierarchy of law, that some laws supersede other laws, has been around for a long time, right? And again, as we say, you can go back to St. Thomas Aquinas, talking about divine law, natural law, and human law. And divine law supersedes supersedes these others. So if you think about how it works in the U.S., what do you have? You have the Constitution, and that supersedes the statutes. So you could have you can't have a statute that violates what the Constitution says in terms of what the limitation is. And then you can have rules. And the question is, and the statute can establish what the rules can be. I don't know if you've been following this at all, but in the state of Michigan, there's an issue about whether the governor's declarations, the rules that the governor's making, are they in violation of the statutes, right? And so there's a bunch of folks, including the Mackinac Center, I think. And the Mackinac Center, yes, the Mackinac Center is involved in a lawsuit saying that the governor has overstepped her authority and is in violation of the statutes. And so this idea that can I just go out and declare anything, right? If I'm the executive branch, can I declare things? Are they in violation of the statutes? So if there's discussion about whether things that Donald Trump is doing in terms of different programs or the like, can this unemployment compensation issue, and whether you can have a $300 extra, and is that possible to do just by executive order? So this issue, there was a bunch of things that happened with the last president, Obama. There was a declaration that he made that said that if the legislature didn't pass something, the Affordable Care Act, that he had a pen and that he could just do it, right? So this issue are the rules or executive orders, are they in violation of the statute? The statute oversees it. So you have these levels of the Constitution, the statute, and executive orders, or what we might call rules. So what is in Econ 105, Hayek says that the Constitution, what does it do? It sets out the general principles by which we govern ourselves. So that if you were to read the Constitution, it should say, here's the general principles of how we're going to govern ourselves. So if you are Mexico and you have what you should do is set out in your Constitution, this is the general idea of what we're going to be doing. And if you're in the United States, your Constitution should say, here's the general principles by which we're going to govern ourselves. Now, different countries have different abilities of the judicial branch to overturn enacted statutes, right? Can the judicial branch overturn a statute because it's in violation of the Constitution? Right? And countries differ on this. So where does it, anybody know where it says, and again, we've gone over this in Econ 105, in the Constitution, in our Constitution, where does it say that the judicial branch can overturn it, right? Parker's going, doesn't, right? It doesn't say any there. So what was that? 1803, Marbury versus Madison, right? So in 1803, Chief Justice Marshall says, in the U.S., 1803, Justice Marshall declares, says, yeah, we can do that, right? The judicial branch can overturn it. And so that's the way we've been running things since 1803 in the U.S. In Britain, the courts don't have this power. All right. So the next section is, you can read on your own. The next section in the book is the court structure in the U.S. There's no reason for us to go through all that. You can take a look at that, knowing how whether you have a, for example, in the Hillsdale County, what kind of courts handle what kind of issues. So anyway, that's all straightforward in the text. So go ahead and read that section. We obviously wouldn't have an essay question on that on the midterms or anything like that, but there might be. I might put in a multiple choice or true-false question about that. But essentially, it's just for your own information about what that looks like. All right, that takes us up to what does a legal dispute look like? Right? So let's just. So we're going to have a dispute over something that happened. What happens is someone feels harmed by another, right? Someone, you feel that you were harmed illegally by someone else, right? That's what a legal dispute's about. Obviously, you say, hey, I got a harm here. You did something, you trespassed on my property, or you crashed into my car, or you shot my dog, or something like that, where you have created a harm and it was in violation of what the law says. So that leads us into what's called a cause of action. Right? That's just a definition, a cause of action. That's this legal, if you have a valid legal claim, you're saying, Parker trespassed on my property, okay? Or Parker violated a contract, okay? So you have some cause of action. You say, okay, there's something happened. I got harmed. It was in violation of a claim. All right, so how does that work then? You file a complaint, okay? So you're the person that got harmed. If you're the person that says, geez, I was harmed, you're going to file a complaint, okay? They did something that, again, maybe we had a contract. They were supposed to pay me. I sold them my car, and then they never paid me. They got the car, or they bounced the check or something like that. Okay? So you're going to say, okay, here's what's happened, and you are the plaintiff. So the person that files the complaint, they're the plaintiff. And when you file the complaint, what do you have to do? You have to say, here's what's going on. There's 5 things you got to talk about. When you file the complaint, what's it supposed to say? Well, basically what happened. Okay? Parker took possession of my car and then never paid me. So then you have to say why you feel that you're injured. Okay, this thing happened, and so why am I irritated? What happened? What was the problem? then you have to say, oh, and here's, right, they had to have done this illegally, so you have to say, you know, what area of the law? Right, so when you're an attorney and you are working for me, you're going to file a complaint. You're going to say, here's what happened, okay? And here's why my client feels they're injured, and here's the area of the law that was involved. And then what statutes in particular, okay, they're in violation of, Michigan compiled law number 14. So what statute is involved? Okay, what is relevant? And then the last thing, of course, is what do you want the court to give the person that's injured, right? What sort of relief do you want the court to give? Okay, so when we go into a legal complaint, you sue somebody. You know, you're the attorney that's running the lawsuit. What are you going to do? You're going to say, here's what happened. Here's why my client feels they're injured. Here's the area of law that's involved. Here's the particular statute that's involved, and here's what we want the court to do. So the person that's named in the complaint is the defendant, right? So you're the plaintiff, and and Parker then is the defendant. Okay. So you have a plaintiff and the defendant, right? So the defendant is the person that was named in the law, and you must answer. The defendant must answer the complaint. Right? So Parker has to say, hey, here's what happened, and why what the defendant intends to argue, sort of a general outline. Okay. So and then the judge is going, okay, I'm going to take a look at this, and then what will happen is you guys decide whether you're going to go to trial or not, right? Whether you're going to let the suit proceed or not. So you feel you're harmed. You're the plaintiff. You lay out what's going on. The defendant, they answer briefly. Here's why we think we're right. And then what will happen is you guys are going to decide, hey, do I want to proceed? Right? So, and of course, that leads us back to our game theory here, right? Do you want to go on to trial? What are you going to use? You're going to take expected value. Right? You're going to take the expected value and you're going to say, what's the expected value of this thing, and what's your probability of winning, what the award's going to be, and what the costs are going to be, right? So you're not certain that I'm the judge and I'm going to rule in your favor, and so there's some probability that's going to happen. And what happens if I rule in your favor, but the defendant decides to appeal? Okay. Well, then you got the cost of going to appeal, right? Now I'm paying $250 or $300 an hour to my attorney to go through with the appellate situation, right? And so we can use what we were deciding. We're going to decide whether we're going to go ahead and just settle, or whether we're going to go ahead and go on and go to trial. So again, this idea of expected value, what's the probability, and what's the probability the other person's going to act in a certain way, right? What's the probability that Daniel's going to go ahead and proceed, right? Or is he just bluffing, right? So you can use expected values, you can use game theory to try to think through, here's what, if I do this, what are they going to do? What's the probability they're going to do this, that, or the other? And of course, again, happens all the time, every day, right? Every day there's court cases and people are filing court cases all around the country. And every day people are deciding, oh, should we settle out of court? Should we go ahead and proceed? I used to be on the State Board of Education. I was on that too, but I was on the board of Lake Superior State University, which is up in the UP, It's up there. And anyway, this other friend of mine he worked for one of the major law firms and he lived in Lansing. And so I would drive up to Lansing and pick him up, and then we would drive the rest of the way up to Lake State and go to the meetings and stuff. So, and then we'd drive back. Well, his name's Dean Altabelli. Well, Dean used to be on the phone all the time, talking to somebody while we're driving up. And I remember lots of conversations where he says, you know what, we're way better off settling out of court, right? Let's not take because if we go to trial, I'm going to charge you lots and lots of money. Here's the probability that here's what I think that you'll get if we were to settle. I think we can settle for X, and you're going to end up better off than if you take on the risk that we're a very good law firm. But because we're a very good law firm, we're going to charge you a lot of money to go ahead and do that. So I remember listening to Dino talk about this all the time. So clearly this happens every day, and you have to figure out whether you're going to go on or not. And I said most cases end up being settled out of court, both criminal cases and civil cases, that is, cases that have to do with violations of contract law or whatever. Now, the judge decides whether there's reason to proceed, right? The judge can say, no, this is silly. We're not going to proceed. So the judge can decide if you proceed. So the judge says, hey, I'm going to dismiss this complaint and offer summary judgment. It was called summary judgment for the defendant. Just say, hey, this is silly. Parker doesn't know what the heck he's talking about. This makes no sense. We're not going on with this. Now, the plaintiff can appeal. So the plaintiff can say, oh, you know what? I'm going to appeal the summary judgment. I think that the judge didn't consider this, that, or the other thing. And that then the dispute can go to trial. The appellate court can say, hey, judge was wrong. We're just going to go ahead and go on with this thing. So I could be the judge, dismiss this, and then you appeal to the higher court, and they say, no, judge, you got to go on with this. You got to hear the trial. Then you could have a jury, or you could have you can request a jury trial, or you can just do what's called a bench trial. Right? So you could request a jury trial. This is in the U.S., right? You could request a jury trial or a bench trial, which is just where the judge makes the decision without a jury. Okay? Now, then we can think of what's the standard for deciding about this, right? I got to figure out, well, who has the better evidence, right? Or how much do you have to show? So if we look at the standard for decision, it differs between, now we're going to use civil law in the other sense. We had talked about civil law as being the statutory law versus the common law. But civil law can also be thought of as the difference between a criminal offense, where you end up going to jail if you do something, versus where you got to pay me with the compensation that I've asked for. So that would be your civil law. So for a civil case, it's a preponderance of the evidence. Right? I don't have to prove the way in a criminal case. In a criminal case, beyond a reasonable doubt. Right? So if it's a criminal case, it's beyond a reasonable doubt. In a civil case where I'm suing you and you're going to give me some money, right, then it's preponderance of the evidence. Famous case, which you guys not, anybody heard of a guy named O.J. Simpson? Okay, all right. Great football player, right? But he had a little problem with his wife, right? And what happens? She ends up dead, okay? So what do? They arrest him as a criminal case that says he killed his wife. And what happened? Did anybody know what happened in that case? Was it like 2 years where finally he was acquitted? He was acquitted, right? They said, nah, not beyond a reasonable doubt, right? But then his wife's estate sued him, civil case, preponderance of the evidence, and he had to pay, I forget, so many millions of dollars to the wife's estate. So same situation. He was acquitted under the criminal case because it was beyond a reasonable doubt, but he lost the civil case where he ended up having to pay the estate of his wife's estate. Okay, so again, the standard for decision is different for a criminal case where you are going to be punished for something versus a civil case where you're going to have to make recompense or something like that. All right. So again, the O.J. Simpson case is a famous case that actually met that, where the exact same thing happened. Right. His wife ended up dead. So the exact same thing happened. Criminal, acquitted. Civil, he lost in the civil trial. Now, in a jury trial, the jury returns with a verdict, right? So I decide I want a jury. They return a verdict, okay? Guilty, not guilty, or you might have a jury trial in a civil case, but the judge ends up making the final decision, right? So in the U.S., the final decision is by the judge. So normally, the judge goes along with what the jury said, but they could enter a judgment and override what the jury said, right? So the jury could say, okay, we think that the plaintiff wins, and the defendant has to pay the plaintiff $500,000, but the judge could override what the jury does, and I'm gonna write this down because I don't know enough Latin. Although, anybody in here use Latin as their language? Not too many? Okay, Josh. And my daughter, she got her PhD in classical archaeology, but she's, teaches Latin and did all that stuff. But when I was at UCSB, I was running track for UCSB, and they had a dean that was in charge of keeping the jocks eligible. So we would have this, I remember we had this big meeting, and we're all in there, and the football players, and I was cross country and track, and the basketball players were all in there, and the language that they told us to take was Latin. So Latin was the jock language that you took, because they still had a language requirement. And the reason was you didn't have to speak it, right? You didn't have to have the, you didn't get the accent right? You don't have to speak Latin. And you don't have to translate anything into Latin. And there was, at least in where we were, you didn't have to translate, you had to translate from Latin into English, but not the other way around. And so anyway, all the jocks took Latin, and so I took Latin, but it was long enough ago, I don't remember it. Okay, so it's called judgment non obstante verdicto. Okay, so that's what it's called when the judge decides to do something which is against what the jury decides, and that is, it's not frequent that happens, but occasionally that could happen. But the point is that it is the judge. Better look at that. The judgment non obstante verdicto, which is it's in your textbook as well. But the issue is that technically the judge makes the decision and can override what the jury said. Now, in a civil suit, either party can appeal. So whoever won can appeal. So you can go to the appellate court and make an appeal. Now, let's say you were asking for $50,000 and you only got awarded $25,000. You might say, oh, okay, I'm going to go ahead and appeal this case and see if I can make some more money. Or the loser thinks that they shouldn't have lost, right? I was supposed to, I thought I shouldn't have to pay at all. I don't think I violated the contract, and yet the judge said I have to pay the $50,000. So you might have won in the sense that you got awarded some money, but you might think that you didn't get awarded enough money. So whoever is, either party can ask for an appeal. And again, if you know that these are the rules of the game, right, you got to figure this into whether you're going to go to court or not, right? Knowing that, hey, I could win at the lower level, but this could be appealed, and then if it gets appealed, I got to spend the $300 an hour with my attorneys to go through the appellate process as well. That makes the decision, okay, are we going to, should I bother spending all this money to go to trial if I think that the defendant is likely to go ahead and appeal, right? So you're suing somebody that's got boatloads of money and you don't have a lot of money. You might think, hey, there's some high probability that what they'll do is they will go ahead and appeal, and knowing, again, it's game theory. They know that I know that they could spend a lot of money appealing, and so they knowing that may can affect whether I know they know that I don't have very much money to spend on the appellate side, and so that will affect my decision about whether I ought to go ahead and proceed, right? Whether we ought to go ahead, or should we just settle out of court, right? And so, again, you can use the expected value in terms of what's the probability this is going to happen times the value that's going to happen, and use the game theory issue of, are we going to, I'm guessing what the other person's going to do, and they're going to know what I'm going to think about what they're doing, and so you'll end up with this whole, reasoning about why it is that so many cases don't end up going to court, either in the criminal case or in the civil case. So, the grounds for appeal, if you're going to appeal, the grounds for appeal has to be about what the relevant law is, not about the facts. Not the facts of the case. You're going to say, you know what? Judge got this wrong. Here's what the law really says. The jury got this wrong. Here's what the law really says. So there's no new evidence in an appellate court, right? Right? I'm not going to add stuff. So if you're an appellate judge, you don't listen to new evidence that comes in. What you're hearing is, oh, you know what? They got this wrong. Here's what the law really says, and they interpreted the law to be this, but it really should be that. And so only you're only arguing about what the law says, and only attorneys for the parties can appeal. Now, so what do? The attorneys submit briefs. So if you're working for a law firm, you're gonna learn how to, or in law school or whatever, or maybe you're going to learn once you're working for the law firm, or you're interning for a law firm or something like that. So you're going to learn about, here's what we're going to do. We're going to submit briefs, okay? And then the attorneys appeal or appear for oral argument, right? So the attorneys show up, and the appellate judge is listening to you, and your attorney's saying this, and the other attorney's saying that, and they're saying, hey, this is the relevant law. The judge, the judge got it wrong, or the jury got it wrong, and so here's why we're appealing. You can file what's called an amicus curiae. That is a friend of the court, and you could file, even though you're not involved, it might be something that you're not involved directly, but it might be something that this decision is going to affect you. So I think the Mackinac Center is that, yeah. So the Mackinac Center in this case filed an amicus curiae. That is, they said, okay, even though we are not directly involved in this, whatever the judge decides is going to affect us, and so we can file a brief as well. So it's not just the attorney for the plaintiff or the attorney for the defendant that can file a brief. If you think the judge can accept an amicus curiae, that is, can accept a brief from somebody that is going to be affected directly by what the outcome is. The appellate court then issues a written opinion. Okay? So the appellate court issues an opinion. And it might be unanimous opinion. It might be where you have dissenting, and they will write out. I don't know if you ever looked at this, but if you ever looked at decisions, oftentimes they talk about Supreme Court decisions, and one of the Supreme Court justices will write a dissenting opinion. So let's say it's a 5-4 decision. The Affordable Care Act, right? There was a decision about whether the Affordable Care Act was unconstitutional, and it was a 5-4 decision that said it was constitutional because they weren't requiring you to buy insurance, but there's a penalty for not buying insurance, which is a tax, right? That's why they structured the Affordable Care Act. That is, if you don't buy insurance, right, you're required under the Affordable Care Act to buy insurance. Okay? If you don't buy insurance, what's the penalty? The penalty is a tax, and under the Constitution, Congress can require you to pay taxes, right? And so that's how that thing got decided in a 5-4 approval. And there were dissenting opinions that were written. So if you look up the Affordable Care Act decision, you'll see that the majority wrote, they wrote what their opinion, but you could have dissenting opinions. So it might be unanimous. It might be that the Chief Justice just writes out, here's the opinion, everybody just goes along with it. Or it might be that 2 or 3 of the judges may decide, here's my reason for making this decision. And in the case of Michigan, where judges are elected, not all states are that way, but in the case of Michigan, judges are elected. It may be that when you're a judge and you're crafting what your written opinion is, you know that when you're running for office, that written opinion is going to be sitting out there. Okay? In a number of states, judges are appointed, but in the state of Michigan, judges from the Supreme Court on down to your local courts are elected. So anyway, the point is that the appellate court can has a written opinion, and they can either affirm the decision, say, yeah, judge got it right. They can reverse it and say, nah. Or they can remand it back to the lower court. And say, no, hey, you guys goofed up, wrong, got the statute wrong, so I want you to hear this case again, right? So the appellate court can say, hey, they got it right. They can say, hey, they got it wrong. Or they can say, we're not deciding whether they got it right or wrong, but they had the wrong element of the law, and here's what we want. We want it to go back to the lower court and remand the decision back to a lower court for specific damages. All right, so we have now covered Chapter 3, and so for the rest of the semester, we're going to be looking at the Chapter 4, which is economic theory of property law. And so you'll notice that in all the topics, there's 2 chapters, one of which is outlining here's what here's what property law looks like, here's the, taking some of the things that we've learned definitionally in the first 3 chapters, and then there'll be a chapter called topics in property law, and then looking at specific topics. All right, there are some in your folder. You'll see example questions. Some of these are much more difficult than, not much more, but more difficult than you're going to be able to do in a 50-minute exam. But if you can answer that question, you know it really well. You might just go ahead and take a look at that. And I will, before the end of the semester, probably in the next week or so, I'll maybe alert you. This question's so more likely, to be in there. Those had Econ 105, right? I put all the old exams on the server, so you'll have a pretty good idea what the questions are going to be like when you go in to take the midterm. All right? All right.